When P&O Ferries decided to sack 800 workers, or 786 to be precise, in the case of some of them by Zoom, there was a justifiable outcry and questions about breaches of employment law. This is no way to treat staff, especially not those who worked through the pandemic. And in this febrile post-Brexit world, some on the Remain side saw this behaviour as a consequence of Brexit. In fact, the UK has not taken advantage of its post-Brexit freedom to depart from EU-derived employment law. That law was carried over into UK law as retained EU law and has not been amended. The reality is that UK employment law on dismissal was, and still is, flexible. It's easier in the UK to fire employees than elsewhere in Europe, and that's what P&O seem to have done. To use a contract lawyer's term, they've made an efficient breach. Let me explain. We'll begin with the two exam questions. First, does UK law apply to the dismissals? When it comes to P&O Ferries, UK employment law will apply, irrespective of what law governs the contracts, as mandatory rules, and P&O don't appear to deny this. UK law will apply to the P&O staff, provided that those sacked come within the territorial scope of UK law, that is, that they ordinarily work in Great Britain. The second exam question is, has P&O Ferries breached employment law? Now, there really is a fog of uncertainty around the precise facts, but the following is likely to apply. For those employees with 2 years or more service, if this is a redundancy situation, and this is by no means clear that the statutory test for redundancy, which is there a diminution in the need for work of a particular kind, has in fact been met. But if it is a redundancy situation, they may receive statutory redundancy pay, plus a higher amount if the contract offers more favourable provisions. For a 40-year-old man, let's call him Ben, with 5 years' service, earning £600 a week, the statutory redundancy payment comes in at £2,720. Ben may also be able to claim unfair dismissal compensation due to P&O's failure to, first of all, consult the workers as individuals, and second, consider suitable alternative employment for those workers. Now, P&O Ferries says it has actually done this. It has looked for suitable alternative employment. If it's not a redundancy situation, the employers will likely argue that the dismissal is justified on the grounds of SOSR, some other substantial reason. If P&O succeeds, there will be no redundancy payment, but the dismissal is still likely to be unfair due to the failure to consult with the individuals, and the average award for unfair dismissal is about £10,800, but there's no guarantee that Ben will receive as much as that. Now, all employees with or without 2 years' service will have a claim for wrongful dismissal, that is, dismissal without any notice. Their compensation will be their pay for the notice period, often a month's notice, so in Ben's case about £2,400. Now, it is theoretically possible to seek an injunction restraining P&O from breaching UK employment law, but injunctions are rarely granted. Now, everything I've described here is long-standing UK domestic law. It has nothing to do with the EU at all. All member states of the EU have laws regulating dismissal, and they are not harmonised at EU level. The one bit of law which does come from the EU and is now retained EU law in the UK concerns collective redundancies, that is, 20 or more redundancies within a period of 90 days or less at one establishment. Where an employer is proposing to make collective redundancies, the employer must consult with trade unions or elected worker representatives. They must do so in good time and, in the event, at least 45 days before the first of the dismissals takes effect. Where there are more than 100 employees at one establishment, if there are less than 100 employees, it's 30 days before the dismissals take effect. Now, none of this has happened, as P&O Ferries have absolutely admitted. No consultation was carried out in advance, they say. In special circumstances where it's not reasonably practicable to comply with the obligation for full consultation, the employer must still take such steps as are reasonably practicable to consult. This doesn't appear to have happened here either. So, as a result of these breaches, employees are entitled to a protective award of up to 90 days' pay, which would be about £7,700 for Ben. Trade unions can apply for the award on their behalf. Unlike in other EU countries, it's not possible to get an injunction to restrain a breach of the collective redundancies legislation. There is also a separate duty on the employer to give at least 45 days' notice to the Secretary of State where the employer proposes to dismiss 100 or more employees as redundant within a period of 90 days. Now, the Secretary of State's letter to P&O's chief executive suggests this did not happen, and this is a criminal offence. Now, it's worth noting that even if there had been notification, the Secretary of State can't stop the collective redundancies from occurring. All it can do is to try and soften the blow. Now, P&O denies it's committed any criminal offence because it did notify the competent authority, but the competent authority of the state where the vessel was registered, in this case Bermuda, Bahamas and Cyprus. It says it didn't need to notify the UK government. The reason for this is due to an amendment to UK law introduced as a result of an amendment to a 2015 EU law concerning seafarers. P&O Ferries has admitted that, and I quote, "We know that for our people this redundancy came without warning or prior consultation." They also appear to be willing to pay up. "We have offered enhanced severance terms to those affected to properly and promptly compensate them," they say. So on a rough calculation, Ben might be able to receive about $23,600 from P&O Ferries. If that's multiplied by 800 workers, that will cost the company about 19 million. P&O says its compensation scheme will cost 36.5 million, with no one receiving less than 15,000. Now, if P&O's losses are 100 million, paying the employees off in this way may represent an efficient breach. It's a cost-saving way of addressing an ongoing financial loss, albeit one which has ruined the livelihoods of many staff and, as P&O says, caused distress for them and their families. And what about the purported employment of engine workers on $2.38 an hour in place of the SAC crew? If those engine workers are deemed to be ordinarily working in the United Kingdom, they will be subject to UK minimum wage laws. And this hourly rate of $2 and a bit clearly does not meet the UK minimum wage level. So there may be trouble ahead looming for P&O on this front. So the final question, is UK law on dismissal more flexible than those laws across Europe? In a word, yes. The OECD ranks all countries in order of strictness of employment protection, individual and collective dismissals, regular contracts, that's the title they use. The OECD average is 2.06. The US is the most flexible at 0.09, with Canada next at 0.59. Ireland is fifth with a rating of 1.23, the UK sixth at 1.35. This stands in stark contrast to France and Germany, which come in at 35th and 36th on the OECD rating, with figures of 2.56 and 2.60 respectively. So according to the OECD, it clearly is easier to dismiss workers in the UK as compared to France and Germany, as the staff at P&O have found out. But it must be said, this has nothing to do with Brexit.
Dear world, yours